Expressions hair design is a case about the legality of state bans on surcharging credit card transactions. What those laws say is, if, for example, the merchant's price is $100, the merchant cannot charge more to customers who choose to pay with a credit card, even though credit cards are quite expensive to accept, and even though the merchant is paying an out-of-pocket cost for that. A number of small businesses and consumer groups have challenged these laws and said they violate the First Amendment, and so the court will ultimately decide whether a merchant is allowed to characterize this differential pricing as a surcharge. The challengers say that this is just a simple restriction on speech, and the key to the challengers' position is that discounts are permissible. So it's perfectly fine for a merchant to say, here's our price, and if you pay with cash, we'll give you a 3% discount. But if they instead said, here's our price, and if you pay with a credit card, we charge you a 3% surcharge, that all of a sudden becomes a crime. And now, of course, as a matter of math and economics, those two scenarios are pretty much exactly the same, but the state is saying you can call it a cash discount, but you can't call it a credit card surcharge. What Expressions Hair Design and its supporting amici are saying is this is just a straight up regulation of the words we can use to communicate a message about how we price our products. And then the defendants are Eric Schneiderman, who's the Attorney General of New York, and then city and county officials from New York City and Long Island. So Schneiderman, he argues that this isn't speech at all, and this is actually the argument the Second Circuit embraced in the decision below, that this isn't speech at all. So the First Amendment doesn't even come into play because it's just economic regulation, it's just regulation of prices. So, for example, if a state has a law that says no one can charge more than $3 a gallon for gasoline, if a company then advertised gasoline for $3.05, that wouldn't be protected by the First Amendment because it's an unlawful price and you're making an offer to engage in an unlawful transaction. It's undisputed that a merchant can charge different prices for credit card transactions and cash transactions. And the only question is whether you're allowed to label that as a cash discount or a credit card surcharge. The regulation has everything to do with the label being placed on the speech and nothing to do with the prices themselves. If Expressions wins, it would mean that them and all companies would be able to charge a higher price to customers for the convenience of paying with a credit card.